Good afternoon. We're going to continue with our agenda here with item number 1, which is docket number 2024-021, cause number 600-06, in the matter of the request for agency action of XCL Resources LLC on behalf of XCL ASSETCO LLC for an order amending the board's orders in causes 139-138, 139-143, and 600-04 to reduce heel toe setbacks from 330 to 100 feet for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch or Colton formations in sections 26, 27, 28, 33, 34, 35, 2 South, 1 West, USM. And I believe we have appearance of counsel.
Thank you, Madam Chair. Mitch Mayo of Lear & Lear, PLLC, on behalf of the petitioner in this cause, XCL Resources and XCL ASSETCO.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you.
Madam Chair, thank you again. As I said, I'm here on behalf of the petitioner in this cause, XCL Resources and XCL ASSETCO. With us today, appearing electronically pursuant to order of the board, entered on April 18th, are Mr. Kevin Anderson, Vice President of Business Development and Land for XCL, Mr. Josh Sigler, the Vice President of Geology, and Mark Gravey, the Executive Vice President of Reservoir. The witnesses are appearing electronically, so I have my cell phone on. If it dings, I apologize in advance. Please, could we have the witnesses sworn in at this time?
Please raise your right hand.
And I don't see them on the screen.
Stand by. We're bringing them up right now, Mitch.
Thank you.
Okay. Please raise your right hand. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
We don't have everyone on the screen.
Yeah, we're moving over to the other view. Give me 1 second.
Our conference room video wasn't working, so we had to go individuals.
Okay, we should. That's everybody that's online right now, so we should be good to go.
Thank you.
We're missing Josh.
Yeah, is Josh available?
Yes, I think sorry, we had technical difficulties on our end.
Well, I know we're starting a few minutes earlier than we anticipated to.
I guess he's trying to get in right now.
Are we getting close?
Is it worth running through mine and then we can swear Josh in when he gets here?
We don't have any idea how long he's going to be, so if you guys tell us it'll be a few minutes, I guess board chair will make a decision.
He said he was logging in.
I don't know what happened. I know he had to travel today and he expected to be at the computer, but if needed, I could testify on his exhibits as well, as I'm very familiar with them. So maybe we could move, and if he arrives, we can swear him in, but I apologize for
There you
There he is.
Ears are burning. The professor.
You guys have me loud and clear?
Can we
Yes,
go?
we do.
Can we go back through swearing in the witnesses?
Yeah, Madam Chair, can we please have the witnesses sworn in?
Please raise your right hands. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Mr. Gravy, I think you have your left hand up.
Well, it reverses it on the camera for me, so.
Okay. Just making sure.
I do.
All right, thank you, guys. An inauspicious start to the hearing, but hopefully we'll get on track here. Madam Chair, thank you for that. The resumes of Messrs. Annenson, Gravy, and Sigler have all been submitted as part of Petitioner's Exhibit 1 in this cause. If separately asked about the contents, they would confirm the same as true and correct. Although Mr. Annenson has been recognized as an expert in petroleum land management in causes before this board in prior hearings, he will solely be testifying as a fact witness today. However, given Mr. Sigler and Mr. Gravy's recognition as experts in their respective fields, geology and reservoir engineering in multiple prior causes, most recently in cause 130-29, I would ask that they be recognized as experts in those fields for purposes of this cause as well.
Division,
Yeah, no objections.
board. They're qualified.
Thank you. Also, with the board's permission, as a standard practice, I'll be moving for admission of exhibits at the end of our close of our case in chief. Brief background for you today. XCL is here before you to request what is now a fairly straightforward and simple request to reduce the heel-toe setbacks from 330 feet to 100 feet on a couple of 1280-acre DSUs and 2560-acre DSUs. The relief requested today, as board chair mentioned, necessitates the modification of 3 separate orders, 2 that established 1280s, 139-138 and 139-143, and 1 that established the 2560 units at issue here, and that's cause 600-04. I may refer to those collectively as the current spacing orders. The current orders collectively impose 330-foot heel-toe production setbacks on wells drilled on the subject lands. However, after extensive horizontal drilling, XCL has now collected data sufficient to come in and reduce those setbacks to 100 feet, and that's what they're here for today. The relief requested is similar to and consistent with relief granted in prior causes, particularly that cause mentioned earlier, 130-29, which, as you'll see in exhibits presented later today, constitutes the adjoining sections of land that XCL operates. Excuse me. The other offset order recently entered by this board that's illustrative is cause 130-16, which is in February of last year, where just to the west of that land, Ovintiv was granted 100-foot setbacks. The board has jurisdiction over this cause pursuant to 40-6-5 and 40-6-6. Notice was provided as required under Utah law to all interest owners and to all relevant governmental agencies, and each of these mailings was sent either to the address provided by the governmental agency or to the last known address of record in the office of the Duchesne County or Uinta County recorder, as may be applicable. In addition, notice was published in the Uinta Basin Standard and Vernal Express on April 3rd, the Deseret News on April 5th, and the Salt Lake Tribune on April 7th. No one has filed a protest or objection to the requested issue in this cause. However, the division filed a response and notice of non-opposition on April 10th of this year, which noted that, quote, the division does not oppose the request, end quote, that the request today, quote, is similar to other relief granted in the area, end quote, and that, quote, the board should grant petitioner's request, end quote, if sufficient supporting evidence is presented today, and we believe it will be. Finally, it's worth noting that XCL has notified all offset operators and none expressed concern with or objected to the request. Again, all other interested parties receive timely notice. With that, I will begin my examination of Mr. Annenson. Mr. Annenson, are you there? Can you hear us?
Yes, sir.
Okay. Could you begin by stating your name and business address for the record?
Kevin Annenson, Vice President of Business Development and Land, 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007.
Okay. And as the VP of Business Development and Land, do you exercise a supervisory role over the lands at issue?
That's correct.
Okay. Could you please provide the corporate and bonding status for XCL for the record?
XCL is a Texas corporation in good standing, having its principal place of business in Houston, Texas. We are fully bonded with all relevant federal, Indian, and state of Utah agencies.
Okay. And briefly, can you just hit on the relationship between XCL Resources and XCL ASSETCO?
Resources is employees. ASSETCO operates management service agreement such that Resources manages the assets for ASSETCO.
Okay. So they're sister entities with different responsibilities.
That's correct.
Okay. And I'd like to remind the board that Mr. Annenson will be testifying as a fact witness today, so there's no need to qualify him as an expert in this cause. With that, we're going to turn to your first exhibits. Mr. Annenson, do you recognize what's been filed and should be on the screen in front of you as Exhibit 3, Exhibit 4, Exhibit 5, and Exhibit 6? Do you recognize these?
I do.
And were they prepared by you or under your direction or supervision?
Yes, that's correct.
Okay. With Exhibit 3, can you orient the board as to where the units at issue are located in the basin?
Sure, no problem. So this is, as you can see, the city of Roosevelt, located there in 2 South, 1 West, which is that red star. We are the red outline there on the border of Duchesne and Uintah County, just to the southeast there of Roosevelt.
Okay. And turning to Exhibit 4, it identifies clearly some units and orders. Can you walk the board through the orders that are applicable to the cause here?
Sure. So this exhibit demonstrates a couple of important things. One thing it shows is the lands that are subject to this request, which was spaced for the 1280 development pursuant to 139, 138, cause number, and then cause number 139. -143. The one there in blue, which is the 139, 138, established 2 of the 1280 DSUs at issue. And then the order 139, 143, there in the yellow, established the 1280 DSU at issue. All 1280 units have production setbacks currently at the 560 lateral east-west, and then the 330 heel toe there to the north and south.
Okay, so each of these 3 units, these are the 3 1280s that the board is being asked to reduce today. And currently the setbacks on those are 560 feet laterally and 330 foot heel toe.
Yep, that's correct.
Okay. Turning to Exhibit 5 and Exhibit 6, and we may talk about these a little bit together. For Exhibit 5, clearly this demonstrates 2560 units. Can you tell the board about these and relevant to the setback reduction we're requesting here?
So this shows the 2 overlapping 2560 DSUs that you just mentioned that were established by the board in Order 600-04 as units number 1 and 2. Unit number 1 is 26, 2 South, 1 West, 26, 27, 34, and 35 there on the red dashed. And then unit number 2 on the map to the right, there is 2 South, 1 West, 27, 28, 33, and 34.
Okay. And so those are stand-up oriented units, correct?
That's correct.
Okay. And so that, would you talk through the setbacks for your 2560 units when it comes to how you're allowed to produce those?
Sure. So the heel toe north-south setbacks are similar to on the previous slide for the 1280s that are set at the 330. But to minimize the waste, there are no lateral setbacks per se, because the board determined that any well drilled within that 560 feet of the section line between those two adjoining 1280s is payable on the 2560 section allocation.
Okay. So relevant to this cause, the takeaway is the 1280s at issue and the 2560 at issues all currently are subject to 330-foot heel-toe production setbacks.
That's correct. And for these units, we'll be asking for the 100 feet.
Okay.
So,
Now, we mentioned earlier that there was a related cause that had been pursued and granted earlier this year. Can you talk through slide 6 and help the board understand that all the units in this area have now, following this hearing, will have been reduced?
so Exhibit 6 shows the 1280, 2560 units that were an issue for cause number 130-29. Which was on March 7th, 2024, so last month. So on the left there, the yellow/red, the units that had the heel-toe production setbacks reduced to the 100 feet. So right there to the west of them. And then on the right would be units that are at issue today, which would be those blue units. So literally the units just right next door. And the reason why we didn't do them all at the same time is because we were waiting for some of the offset information from some of the other operators to provide to us so that we could make sure we had proper notice.
Okay, that makes sense. Let me check here and make sure I've got. And just to be clear, there's nothing new about this. Is it fair to say the request today is identical as the request sought and granted in 130-29?
Yep, that's correct.
Okay. And you mentioned
It's a
notice.
continuation of the heel toe. Yep.
Oh, sorry. Go ahead.
Oh, I'm sorry. I spoke over you. I apologize. I said just a continuation of the heel toe as we go through development.
Okay. You mentioned notice and kind of a need to break this up into two for notice addresses. Can you briefly talk about who was noticed and how that was accomplished for the lands at issue?
Sure. So go through and we look at our internal decks. We review all of our title opinions, both ones that we received through Axia and ones that we've updated. We always get all of our title opinions updated just to ensure we've got the most recent title. We also go through and look at the county records, both at Duchesne and Uinta, both counties being, since we are here on the border, you can actually see that goes through one of the sections or two of the sections there through 2734. So we went through and made sure we had all the updated addresses, information that we could find. And then we went ahead and noticed all parties. We also contacted and received the same information, the title opinions from the offset owner, so that we could ensure that we notified the right parties, including those operators. And then we also did the research in those offset units just to ensure that would be affected by the 100 feet.
Okay. So the production interest owners within the subject lands were notified, and you notified the working interest owners and the unleased owners outside the units.
Yes, that's correct. Thank you for clarifying.
Did you receive any responses substantively to this? Any objections or protests internally that aren't part of the record?
No, we did not.
Okay. One final question. In consideration of your land exhibits, do you believe that reducing the setbacks protects correlative rights but also maximizes resource recovery and prevents waste?
Yes, I do.
Okay. With that, I have no further questions for Mr. Annenson and can move on to Mr. Sigler, presuming he's available.
I am once I find that mute button. Good now?
You found it.
Yep.
There you are.
Can I just ask a question of Mr. Anderson?
Of course, yeah.
Thank you. Mr. Anderson, just really quickly, talked about notice. I just want to clarify, Altamont Energy owns 2 existing wells in the subject lands, and XCL, I believe, has 3. Is that correct?
Yes, that sounds correct.
Okay, and I just, can you confirm that Altamont did receive notice of this request? And have you heard any comments back from them?
They did receive notice, and we have not heard back any comments.
All right, thank you.
Thank you.
Mr. Sigler? There you are.
Yes, sir.
I'm going to turn to you now. Can you please state your name and business address for the record as well?
Sir, my name is Joshua Sigler. My business address is 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007.
Okay, and your current position with XCL?
I am the VP of Geology here at XCL Resources.
Okay, and in that role, do you exercise a supervisory a position over the records associated with the lands at issue?
Do, sir.
Okay. Based on earlier stipulation and determination by the board, I'd like to remind everyone that Mr. Sigler will be testifying as an expert in geology today. Mr. Sigler, I'd like to just go through your slides really quickly. The board has seen these versions of these several times, but if you can identify for me what's been filed as Exhibit 7, Exhibit 8, Exhibit 9, and Exhibit 10. Do you recognize these exhibits?
I do recognize those exhibits.
And were they prepared by you or someone under your direction or supervision?
I would say that 7, 8, and 10 have been prepared by someone under my supervision. I believe we'll save number 9 for Mr. Gravy.
Perfect. Thank you for that. If it please the division, I'm going to have Mr. Sigler testify to 9 the extent he needs to, subsequent to Mr. Gravy authenticating it and testifying fully about it.
That's great, that's fine.
Okay, thank you. I don't imagine we'll hit on it much, Mr. Sigler, but FYI. Exhibit 7, the type log. Can you please help the board explain what this, or help explain to the board what this shows?
Absolutely. This is a type log from the Emerald Phoenix well found in section 2, or in Township 2 South, 1 West, section 31, with an API which is just adjacent to the subject lands. We chose this as a type log because it is a very excellent example of a modern log suite adjacent to the subject lands. This well has an API number of 43013-51290. In this type log, we are showing a gamma ray track on the bottom, which we use for lithologic correlation, and a resistivity log on the top, which we use for interpretation of fluid typing within the reservoirs. This type log extends from the Uinta Formation on the left side, down through the upper Green River into the lower Green River, and finally, at base, we are showing the Wasatch Formation, giving a good type log of the intervals that we generally target for horizontal development, where we'll probably talk to you guys soon about some wells that might fall a little deeper on the log. But currently, this shows a great example of those formations that we target for horizontal development, particularly from the marker noted as the Douglas Creek marker down just below the Wasatch marker. So we effectively target lateral development within the lower Green River and Wasatch formations.
Okay, thank you for that very comprehensive answer. Turning to Exhibit 8, the cross-section. First off, can you identify, is the Emerald Phoenix represented on this cross-section, and then can you walk the board through what this shows?
Yes, sir. The Emerald Phoenix, if you are looking at the cross-section on the left, is actually the central well in there. And if we were trying to count from the map, I'd go to A prime on the far right and count 1, 2, 3, 4 dots over, and you would be at the Emerald Phoenix well. And so, in effect, we have a cross-section ranging across our stand-up units in 2 South, 2 West, and 2 South, 1 West here. And generally, we focused in now, shrinking that type log down to cover only the lower Green River and uppermost portions of the Wasatch. Again, showing the really excellent consistency that we have, excellent markers such as the Douglas Creek carbonate marker, TGR3 above our producing intervals, And then down into the Uteland Butte and the Wasatch, where those markers really give us great correlation and show the excellent consistency of the reservoirs we develop horizontally.
Okay, thank you for that. And just to be clear up here, you talked about this inset. I'd like to note there's two different colors. Tell the board what those are, just so they're clear.
Absolutely. The green are the at request today, and the red are those lands that were granted reduced setbacks in request 130-29.
Okay, thank you for that. Finally, exhibits 9 and 10. Would you like to talk about exhibit 10 or 9 or both? And which do you think Mr. Gravy should handle?
Well, there is a small portion of number 9 that I would like to hit on real quick.
Okay.
Over on the left, those reservoir properties such as porosity and permeability come directly from core. That's also collected relatively close to this unit in 2 south, 2 west from one of the cores that we have collected, giving us excellent reservoir parameters. Continuing, and it's actually the one of the wells that's on the cross section. But giving us excellent control on what the reservoir properties look like here, helping us to understand what we can expect in terms of drainage radius. I'd prefer to let, as Mr. Gravy is our expert in drainage, I'll let him speak to the calculations we get to here. But if we were to move on to 10, we see the orientation of fracture half lengths, or our interpretation of maximum horizontal stress, which would then drive the orientation of hydraulically generated fractures from our horizontal wells. At subject here, we are estimating the maximum stress orientation to be at about 6 degrees from east-west. That was generally based on wells to the west of us. We actually now have an additional data point in this unit, a pilot hole, or in these subject lands that was actually drilled as we've been working toward development of this unit, that shows a nearly identical orientation. And so we have great control to the west, and now that we've actually drilled another well, we actually see nearly east-west maximum stress orientations as well on these subject lands.
Okay, perfect. In consideration of these exhibits and your testimony and your expert opinion, do you believe reducing the setbacks here, the heel-toe setbacks to 100 feet will protect relative rights and maximize resource recovery on the subject lands?
Yes, I do.
Okay. Stick around if you would. There may be a question from the division, and also after Mr. Gravy, they may have some follow-up for you. But with that, I'm done with Mr. Sigler for now.
Division, do you have questions?
Thank you. The division was just curious what the name of the pilot well was in those lands.
Yeah, great question. That is the LAMP 53. It is a well that will be utilized as a horizontal producer within in one of our development units, and it was initially drilled deeper down through our horizontal targets and logged with a number of different logging tools, but one of which being a image logging tool, or a resistivity-based image logging tool, giving us similar orientation and readings to those stress orientation bubbles that are seen there on the map today.
Moving ahead.
Okay. Mr. Sigler, hang tight, but it's Mr. Gravy's turn now. Mr. Gravy, are you available?
Yes, I'm available.
Oh, great. Can you please start by stating your first and last name? Spell your last name if you could, and then state your business address.
Sure. Mark Gravy, Gravee. I'm the EVP Reservoir and Development, XCL Resources. Our office is 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007.
Okay. And your job position and generally and your job responsibilities as they relate to this unit.
To oversee the development and planning for this unit.
Okay. And your position is the executive vice president of Reservoir. Is that correct?
That is correct.
Okay. Again, I'd like to remind all that Mr. Gravy has been recognized and will be testifying as an expert in reservoir engineering in this cause. Mr. Gravy, I'm going to be showing you what's been filed as Exhibit 9, Exhibit 11, and Exhibit 12. Do you recognize these three slides?
Yes, I do.
And were they prepared by you or under your direction or supervision?
Yes, they were.
Okay. Let's start with, do you have a preference on starting with 9 or 11, Mr. Gravy? I'd typically like to start with 11, but I think 9 makes more sense.
I don't have a preference.
Okay, let's walk the board through Exhibit 9. Mr. Sigler pointed out the porosity and permeability numbers on the left hand of the exhibit come from actual data on one of the wells presented on the type log. Can you walk through the rest of the tables and how they support this request?
Sure. The right-hand side of the page is an example from the division staff memorandum. And so none of those numbers are changed. That was a example they provided. And on the left-hand side is working through the same calculations, but with our understanding of the variables associated with our rock. And so we did this to generate a Hale and Evers model to follow along with that memorandum and calculate a drainage area. We then took the same concept, but in a slightly more robust computer model called IHS Harmony or FICET. It does similar calculations in a little more robust method, inputting the same information. And we found them to be very similar to one another. Additionally, we find that the minor ellipse of that drainage ellipse is fairly close to the widest we put clusters in the wells. So you complete a new wellbore, you shoot holes in it every X footage, and the widest we would ever go is the minor radius of that ellipse. So all these things tend to align with one another, and the results are there in that red box on the bottom left-hand side of the page.
Okay. So that's kind of the take home from this slide. The footage is there for the different distances, and I'm guessing that correlates to this, and maybe you can explain it with this.
Yeah, that's right. So if you take those same footages and then extend them along the angle that's shown on the diagram relative to what we believe the stress orientation to be in this area, you can rotate that ellipse and estimate where we think the radius is a payout and how it extends through time. Which is consistent with how we've approached historically, as well as other operators, and in line with the guidance from the technical memorandum.
Okay. So the gist is you believe the 100-foot setback is protective of drainage and offsetting units up to 10 years and beyond.
I think it's consistent and protective of correlative rights. Yes, I agree with you on that, Mitch.
Okay. Thank you. Slide 12, walk through some of the economics of just this simple setback reduction for the board.
Yeah, and this is consistent with what XCL has seen not only in the basin, but across the country. Lateral lengths will continue to extend. As lateral lengths extend, it'll reduce surface impact. It'll allow for more resources to be accessed. Right now in the Uinta Basin, I would say the majority of operators are focused on the highest quality resource, but there's a tremendous amount of resource that is being discovered, and longer laterals, including fairly subtle changes, lateral lengths like this, improve the economics, and improving the economics increases the likelihood of development. So here on the 330-foot setback, you're seeing we're recovering about 940 MBO, whereas a 100-foot setback is recovering about 985 MBO across the life of the well. This increases tax revenue from 3.56 million to 3.74. The royalty revenue on a per well basis from 9 million to 9.4, and then compounded over a 12 well development, 42.7 million, taxes increased to 44.9. And royalty revenue from 108 to 112.8. So
even small changes to the lateral length can have big economic impacts.
Absolutely. So just it's really the only chance in the life of the development of a specific resource to capture it. You're not going to drill a horizontal well in that same target, in that same unit, at that same footage again. And so extending the lateral legs, consistent with what the basin has been trending, we believe is the best way to protect recovering this resource and maximize for all stakeholders.
Okay. With that, I'd just like to ask you the final clarification question as an expert in reservoir and in this subject lands in particular. Do you believe that reducing the setbacks on these to 100 feet will prevent waste, maximize resource recovery, yet still protect correlative rights in offsetting units?
Yes, I do.
Okay. With that, I have no further questions for Mr. Gravy and
Division, do you have questions?
We have no questions from Mr. Gravy, no.
Board, do you have questions? Okay.
With that, I'm done with my case in chief. It's probably appropriate now to move for admission of exhibits 1 through 12 inclusive.
So admitted.
Thank you, Madam Chair. And I
Division.
turn my time over to the division.
Thank you. Madam Chair, Board, the division, we reviewed this request for agency action by XCL when we received it. We've also reviewed the exhibits and listened to the testimony given today. And based on the testimony, the division is in support of this request.
Board, do you have any further questions? Are we prepared to make a decision, or do we need to deliberate? We're ready. Do I have a motion?
Yes, I'll make a motion that we approve the request for agency action as requested.
I second it.
All those in favor?
Aye.
Any opposed? Please note, we are minus Gordon Moon and Rich Borden. And Steve Church.
Thank you, Madam Chair. Would you like me to prepare the order?
Yes, if you would prepare the order, please.
I'm happy to. Thank you.
Thank
You
you.
guys are done.
Thank you much.
Okay, just this up together here. Okay, we are now moving on to item number 2 on the agenda. That is docket number 2024-023, cause number 132-36, in the matter of the request for agency action of Oventive USA, Inc. for an order partially vacating the order entered in cause number 139-100 and instead pooling interests, including the compulsory pooling of the interests within certain non-consenting owners in the faucet 14-12, 3-2, 13-24-5H, 14-12, 3-2-13-24-16H, and 14-12, 3-2, 13-24-46H wells in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations in sections 13 and 24, 2 south, 2 west, USM. Please note this matter has been continued to the hearing examiner proceeding on June 19th, 2024, and the board hearing on June 26th, 2024. That concludes item number 2. Moving on to item number 3. Docket number 2024-024, cause number 132-37, in the matter of the request for agency action of Oventive USA, Inc. for an order partially vacating the order entered in cause number 139-115 and instead pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Bar F, Utah, 16-20, 3-2-28-33-7H well, producing from the drilling unit established for the production of the oil, gas, and associated hydrocarbons from the lower Green River Wasatch, comprised of sections 2833, 3 south, 2 west, USM. Mr. Mayo, Do we have appearance of counsel?
Yep, Madam Chair, Mitch Mayo of Lear & Lear PLC on behalf of the petitioner, Oventive USA, Inc.
Thank you. Division?
Assistant Attorney Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you. Mr. Mayo?
Thank you, Ms. Garrison. Mr. Burns, is Chris Wall on? Do you know?
Yes, I believe he is.
Oh, there he is. Hey, Madam Chair, as the board may be aware or may not, Oventive's witnesses are appearing remotely here today, obviously. This was by order of the board, but it was in a slightly different procedural posture than normal. Typically, these matters are set before the board, and about a week before the hearing, if it's uncontested, we'll file a motion in order requesting that they be allowed to appear remotely. In this cause, as the board's probably aware, this matter was originally set to be heard before a hearing examiner this month. However, given the light docket before the board, it was decided that this matter would be better heard before the full board here today. And so the board made an order moving it from the hearing examiner to today's docket, and in that order authorized the witnesses to appear remotely. Now would probably be an appropriate time, Mr. Burns and Mr. Wall, to have them sworn in, if that's all right.
Thank you.
Please raise your right hands. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you for that. Madam Chair, as mentioned, the witnesses here appearing remotely today are Mr. Peter Burns, Land Advisor for Oventive, and Mr. Chris Wall, the Senior Reservoir Engineer for Oventive. The resumes of each have been submitted as part of Petitioner's Exhibit A in this cause, and if asked, they would verify the contents as true and correct. However, each of these witnesses has been qualified as an expert in their respective field in general land management for Mr. Burns and petroleum engineering for Mr. Wall in numerous prior causes, most recently in cause 132-33. Presuming the division has no objection, I would ask that they each be recognized as experts for purposes of this cause as well.
Division?
No objection.
Board? Please proceed.
Thank you with that. Also, standard practice, I will be moving for admission of our exhibits at the close of our case in chief.
Thank you.
This cause requests the compulsory pooling of a drilling unit established for Lower Green River Wasatch production, comprised of the entirety of sections 28 and 33 in Township 3 South, Range 2 West in Duchesne County, sometimes referred to as the subject unit. The subject unit was established by board order entered on July 21st, 2015 in cause 139-134. A true and correct copy of the 139-134 order was submitted as Petitioner's Exhibit B. Pertinent to this hearing, the 139-134 order expressly authorizes the drilling and completion of long lateral horizontal wells, such as the subject well at issue in this cause. Prior to entry of the 139-134 order, there was a single well, and there is still now a single well within sections 28 and 33 that was previously drilled by Newfield, in which Oventive now operates. That well is named the Nickerson 6-28-3-2W well, which I'll probably refer to as the Nickerson well for ease. Again, this is the only well producing or capable of producing from the subject lands. The date of first production of this Nickerson well was March 21st of 2012. Pursuant to order of the board in cause 139-115, the 139-115 order, as I may refer to it, the board compulsory pooled the unleased and uncommitted mineral interests of the estate of Stephen Hullinger in the Nickerson well. In that order, the board imposed a 300% risk compensation award. Oventive believes and therefore alleges that payout under the 139-115 order has not yet been reached with respect to the Nickerson well, and that'll be relevant as we discuss. The 139-134 order was entered subsequent to production starting from the Nickerson well, and the 139-134 order provides that as of the first day of the month following the date of first production of the first long lateral horizontal well drilled upon the drilling unit, which I'll call the conversion date, the previous sectional drilling units comprised of sections 28 and of section 33 convert to the drilling unit basis, and production from any well located thereon, including the Nickerson, would thereafter be allocated on the drilling unit instead of the sectional basis. Pursuant to the 139-134 order, in accordance with approved applications for permit to drill from the BIA and the state, Newfield drilled, and Ovintiv now produces the Bar F well at issue here today, a long lateral horizontal well that produces from the subject drilling unit. As a consequence of that production, allocation of production from the Bar F well is on the drilling unit basis as of December 31st, 2017, being the date of first production of the Bar F well. And the Nickerson well converted to being payable on the drilling unit basis as of January 1st, 2018, being the first day of the month following first production. Any further recoupment from the estate of Stephen Hollinger due under the 139-115 order as pertaining to the Nickerson well has been waived, effective January 1st, 2018. As such, the 139-115 order should also be vacated insofar as it pertains to the Nickerson well and to the subject section 28. This is a somewhat unique cause in that there are no owners of oil and gas who are being pooled here today. The board will be asked to consider the pooling of estates, unprobated estates, and unknown heirs of these probated estates only. This has happened in numerous causes before, but I believe this might be the first time the board has been asked to do this. And so I'd like to note that. Nothing unique about it, but it does feel a little unique. Instead, as mentioned, Ovintiv seeks only to pool the estates that were identified on page 2 of the request for agency action. This is due to a number of reasons, but the primary one being that no confirmatory Utah probate proceedings could be located that conclusively divested the estates of their interests. As such, there is a possibility of some unknown party claiming buy-through under these estates, and they may be referred to as unknowns. Finally, pursuant to order of the board entered on March 13th, 2024 in this cause, a notice of opportunity to participate, naming each of the unknowns, was published in the Uinta Basin Standard for 2 consecutive weeks. Proof of said publication was filed separately in this cause as Petitioner's Exhibit N. No party responded to that notice or otherwise tendered his or her share of costs for the subject well. Ovintiv therefore seeks to have these unknown parties compulsory pooled and declared as non-consenting owners. As to the non-consenting parties, Ovintiv seeks the following: imposition of a 300% risk compensation award, imposition of the terms of a JOA, materially the same as that submitted as an exhibit in this cause. However, during the recoupment period, any unleased non-consenting owners will be entitled to the payment of a 16.808918% cost-free royalty per statute. The board has jurisdiction over this cause pursuant to Utah Code 40-6-6.5 and the implementing regulations. And notice of this hearing and of the opportunity to participate in the Bar F well was duly published and duly sent. One last housekeeping item. The division filed a response in this cause on April 10th, expressing no opposition to granting the request here today. And to be clear, there are no objections on file. With that, if there are no questions, I'll begin my questioning of Mr. Burns. Mr. Burns, are you there and available?
Yes, I am.
Oh, great, thank you. Before we start, can you state your name and business address for the record?
Yes, Peter Burns, and Ovintiv's address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
Okay. And what is your position with Ovintiv?
I'm a land advisor with responsibility over this drilling unit, among others.
Okay. Can you please provide the corporate and bonding status for Ovintiv?
Yes, Ovintiv is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It's duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of Ovintiv Production, Inc.
Okay. Thank you for that. I'm going to show you what's been submitted, but it's going to take me a while to get through them. But I'm going to show you what's been submitted as exhibits C through J in this cause. Do you recognize these exhibits, and were these exhibits prepared by you or under your direction or supervision?
Yes.
I asked multiple questions. I should probably get 2 yeses. I apologize.
Yes, they were. Yes to both.
Thank you. Let's turn back to, let's start with Exhibit C, the locator plat. Please orient the board as to where the unit at issue is located in the basin.
Sure, yes. Exhibit C is a regional locator plat showing the subject lands, sections 28 and 33, Township 3 South, 2 West. This DSU is located approximately 2 miles west of the town of Mighton and approximately 4 miles south of Ioka.
Okay. Exhibit D, mineral ownership in this unit is fractionated. Can you tell the board who owns what and how you determined this information?
Yes, so Exhibit D is a plat of the mineral tracts within the unit. This drilling unit is comprised of 1,280 acres divided into 20 tracts. The following ownership. Tracts 3, 7, 16, and 17 are owned by the United States in trust for the Ute Indian Tribe and the Ute Distribution Corporation, which is administered by the BIA. The oil and gas minerals in tracts 2, 9, 11, 14, 15, and 19, and part of tract 4 are owned by the United States in trust for Indian allottees, which is also administered by the BIA. And the remaining oil and gas in tract 4 and in all of the remaining tracts are owned in fee or private ownership.
Okay, so a substantial portion of tribal ownership in this unit.
That's correct, yes.
Okay. And can you tell me when was the subject well, the Bar F well, spud?
So this well, the Bar F, was spud on September 15th, 2017 and began producing on December 31st, 2017 as outlined in the RAA. So I do want to provide a bit of explanation for the 7-year gap between first production and this request for agency action. So as Mr. Mayo mentioned, there are a large number of lost estates in this unit. So we wanted to try to find more of the heirs, give them more of a genuine opportunity to participate before seeking pooling. Also, in June of 2020, the forced pooling rules changed, making it far more economic to pool these parties, which it gave us more certainty, 30-day election period, also much more economic. Having the forced pooling order apply to the drilling unit and not just wellbore by wellbore forced pooling order. Additionally and lastly, obviously 2021, the COVID pandemic derailed everything. We're still trying to dig out of that backlog for projects that were dropped or changed significantly because of the pandemic, resulting shutdowns and change in personnel within the company.
Okay. Thank you for that. That's helpful. So just to clarify or repeat on the record, the subject well, the Bar F well, began producing. Your testimony is on December 31st, 2017.
Yes, that's correct.
Okay. Turning your attention to Exhibit E. You've kind of hit on this, but can you just briefly discuss this for the board?
Sure. Exhibit E is a plat of the mineral ownership within this unit. Exhibit E shows different types of mineral ownership based on the different colors. The yellow is fee interest. The dark green is allotted tribal minerals, and then the lighter green is Ute Tribal Trust minerals.
Okay. Turning to Exhibit F. It looks, this exhibit is somewhat confusing for a forced pooling hearing. Can you explain to the board why this exhibit is here and what you're really here to do?
Yes. So Exhibit F, this is a working interest summary within this DSU. Oventive is the sole working interest owner and operates the subject Bar F well. There are no other parties in this drilling unit who have executed or are subject to a joint operating agreement. And as Mr. Mayo mentioned at the beginning, Oventive, we're only seeking to pool the unknown heirs and devisees of any unprobated estates. which appear on page 2 of the request for agency action.
Okay. So it's Ovintiv's position that everyone who has an interest in this unit is leased or participating in the unit, but for confirmation that there's an additional area out there that no one knew about.
That's correct, yes.
Okay. Thank you for that. Now I'm going to move on, if I can, to what's been filed as Exhibit G in this cause, the AFE. Can you tell the board what this is and explain who prepared it and when it was sent, roughly?
Yes, this is Exhibit G, which is the original AFE, or Authority for Expenditure, that was prepared in preparation for drilling the Bar F well. This was attached to the JOA. It includes the estimated costs for drilling the subject well.
Okay. I'd like to note that because this is a pooling requesting simply the pooling of unknown and unlocatable owners, no one was sent a copy. No one who's being pooled here today or being asked to be pooled here today was sent a copy of this AFE or of the JOA. They were simply provided a notice of opportunity through publication. But because the board is used to seeing these exhibits, we thought we'd spend the time to talk through that they do exist and they were submitted to owners who do have addresses of record. So I apologize for that clarification. Mr. Burns, Exhibit H, the JOA in this cause. Can you tell the board what this is?
Yeah, Exhibit H is the JOA. This is the JOA that was attached to the request for agency action as Exhibit 1, which will govern operations between Ovintiv as operator and the non-consenting compulsory pooled parties or estates. This is a standard industry form supplied by the American Association of Professional Landmen. This particular form is Form 610, which is the 1989 version that has been modified to address horizontal wells. The terms and conditions contained herein are consistent with other JOAs executed by other working interest owners in this, not necessarily in this unit, but in others where Ovintiv is the operator, and commonly found in more recently developed horizontal well drilling units. Ovintiv has prepared identical terms for other units in which we are the operator, and we've agreed to similar terms in drilling units where we are a non-operator, including units operated by Uinta Wax, Javelin, and other major Uinta Basin operators.
Okay. I'd just like to note a couple key provisions that the board usually needs to kind of know about from these JOAs. Page 7 of the JOA reflects the risk compensation award, or the non-consent penalty that's contained in the JOA. Is that this page? And can you tell the board what non-consent penalty is applicable to this JOA?
Yes, so this page 7 addresses the non-consent penalty. In this particular one and others where we're the operator and non-operator, a 100%, 300% non-consent penalty is provided, which is, there are no other working interest owners in this unit, but this matches all others that we agree to as a non-operator and provide to other non-ops when Ovintiv is the operator.
Okay. Thank you for that. Exhibit C, the COPUS, as it's sometimes referred to. Please explain Exhibit C and its general use in the basin, or if it's widely used, if it's something you're used to seeing.
The Exhibit C to the JOA is the COPUS accounting procedure. Again, this is a standard industry form, almost universally utilized, similar to other JOAs within the Uinta Basin. First particular page is page C3. Article 3B, this sets the interest rate at the prime rate published in the Wall Street Journal plus 3%, which has been deemed to be fair compensation and to encourage timely payment for chargeable costs and expenses.
Okay. And I'd just like to note for the record, the exhibit submitted doesn't have highlight. I highlighted it for this hearing just to draw it out for everyone's attention. The next call out spot, if you could, addresses overhead. Could you talk through what overhead's allowable in this JOA?
Yeah, this particular JOA outlines the overhead charges of $10,090 for the drilling rate and $1,090 for the producing rate.
Okay. Again, pretty standard overhead costs in JOAs from your experience?
Yes.
Okay. Mr. Burns, in your expert opinion, are the terms and conditions of this proposed JOA reasonable and justified to govern the relationship between any unknown owners of the estates and Ovintiv?
Yes.
Okay. I'm going to turn you to what's been submitted as Exhibit I in this cause, a plat map. Can you tell the board about this exhibit?
Yes, Exhibit I is the plat that was provided along with the RAA, and which is sent out along with any well proposals that are sent to partners or unleased mineral owners. This just shows, gives details regarding the drilling and location of the Bar F well.
Okay. In 28 and 33 on the right half, is that correct?
Yes, so this particular surface location is actually in the southeast portion of section 20 there. And, you know, there was this well was directionally drilled to get into sections 28 and 33. This was a 2-well pad, just the surface location happened to be off DSU.
Okay, so to clarify, from this location, 2 wells were drilled, one down into 28 and 33 and one down into 29 and 32. The well at issue is 28 and 33 on the right side.
Correct, yes.
Okay, thank you for that. Now, the last exhibit I'd like you to talk through, Mr. Burns, is what's been submitted as Exhibit J, the acreage weighted or weighted average royalty calculation. Can you explain what royalty calculation or what acreage weighted royalty will be assigned in this cause and how you got to that calculation?
Yeah, so Exhibit J is the average weighted landowner royalty calculation. This reflects the average fee landowner's royalty for sections 28 and 33 as of the spud date of the subject well, the Bar F well, which was September 15th, 2017. This calculation comes to a total average acreage interest owners, which is not the case in this particular one, but that is part of the calculation for other units.
And you did mention that this unit is fairly interspersed with tribal interests. Did you include those tribal leases in this calculation? And if not, how can we see that from the table here?
No, so any tribal or allotted or state leases, those leases are not included in the calculation.
Okay, so this reflects the fee leases taken and in hand prior to spud of September 15th, 2017.
Yes.
Okay, and to repeat, I don't know if you said this, the acreage weighted royalty applied and requested in this cause?
It's 16.808918%.
Okay. With that, I have no further questions for Mr. Burns.
Division, do you have questions?
Yeah, Mr. Burns. So previously, the board pooled the interest in the Nickerson well, and part of that order was the heirs and devisees of the estate of Stephen Hollinger. Are you able to speak to a resolution you came to his interest with his heirs or devisees? Were you able to lease those parties to the best of your knowledge?
Yes, we were. We were able to lease them via affidavits of heirship, but there is no formal probate for his estate, or even 2 additional heirs that would have potentially gained interest from his estate. So that's why while we believe we've leased everyone who was entitled to an interest, that's why we're proceeding with the forced pooling here today.
And would it be correct to assume that once you determined to the best of your knowledge, there his Azure advises that any suspended royalties were then paid to these parties.
Yes.
Okay. Thank you. No further questions.
Board, do you have questions?
Yeah, I have one question. Do you have a net acreage calculation for the estate of Stephen Hollander? That's,
He owned just under 1.5 acres.
okay, thank you.
Board, do you have any other questions? Thank you. Mr. Mayo?
Thank you. With that, Mr. Burns, please stick around, but you're done for now, so you can put yourself on mute and just watch. Mr. Wall, are you available and can you hear us?
Yes, I can hear you.
Okay, perfect. There you are. Can you please state your name and business address for the record?
Yes, my name is Chris Wall. Business address is 4 Waterway Place Drive, The Woodlands, Texas, 77380.
Okay, and what is your current position with Oventive?
Yes, I am a senior reservoir engineer with responsibility over this well and other wells in the Uinta Basin for Oventive.
Okay, and I'd like to remind everyone Mr. Wall was recognized as an expert in reservoir and petroleum engineering for this cause. Mr. Wall, I'm going to show you what's been submitted as Exhibit K, Exhibit L, and Exhibit M. Do you recognize these 3 exhibits?
Yes, I do.
And were they prepared by you or someone under your direction or supervision?
Yes.
Okay. Let's start with Exhibit L. As Mr. Burns hit on, this well began producing several years ago. Can you walk through board through the drilling costs and the operational costs incurred in the Bar F to date?
Yes, so this exhibit shows the actual drilling and completing plus the operating costs for the subject well through December of 2023. It is reasonable to the original AFE.
Okay. Within a reasonable variance of what was submitted by Newfield.
That is correct, yes.
Okay. And the operating expenses, similar?
Yes. The operating expenses are in line with other wells that we operate in the basin.
Okay. And so the total cost to date for the Bar F well is what?
Including the operating expenses is just over $9 million.
And when I say to date, I should clarify to date being December 31st, 2023. Okay. In your expert opinion, then, these costs were fair, reasonable, and necessarily incurred?
Yes.
Okay. What plugging and abandoning cost does Oventive typically assume for a well such as this?
It's $75,000 per well, which is consistent with costs that are charged to and by Oventive.
Okay.
And that's based on 100% working interest ownership.
Perfect. Okay. Now let's go back to what's been submitted as Exhibit K and Exhibit M. We'll start with K. If you could talk about, well control in the area, development, anything this exhibit shows relevant to the difficulties or risks in completing the Bar F.
Yes. So this exhibit is a plat of all the wells that were drilled by the time the Bar F well was spud. And what you notice there are some wells to the north, and there's one well to the west there, but still have fairly limited well control due to the lack of drilling in the area at the time.
Okay, and this is pretty small, but can I get you to confirm this little dot here next to 28, does that represent the Nickerson well that we've discussed here?
Yes, that's the Nickerson vertical well.
Okay. So limited well control and not a lot of drilling in this area prior to the Bar F coming online.
That's correct.
Okay. Exhibit M you walk the board through this slide as well?
Yeah, so this is a list of some of the risks that are encountered when we develop in the Uinta Basin. So starting with geology, we do have some geosteering risks due to the lack of well control. There's also the principal stress swing in this particular area, and that can cause some risk, especially on the production side. Drilling and operational challenges, it is sometimes difficult to predict what our capital expenses are going to be. Then also we do have some shallow hazards with artesian water flows that have caused issues in the past and even into today. Also, the Uteland Butte is an interval with some high clay intervals, has potential to collapse and stick drill pipe and casing. And even today, we have some recent examples where we have some collapsed casing during our completion activity, which was, the Black Air 7H and the Bruce 42H are very recent examples of that just this year. We have some ending challenges also that result in loss of lateral footage. The Tomlin 46H and back in 2023 is a recent example. Sheared BHA, or bottom hole assembly is what that stands for. While attempting to steer in the lateral, also when we have encountered those issues, sometimes they necessitate us calling a well early or not getting to the completed TD that we would like. And then also on the commercial side, future oil uncertainty is a risk. And then future refinery and rail car availability. So in other words, some of our marketing challenges that we have in the Uinta Basin that are fairly unique to the basin, where limited oil market means that we're going to pay a price to actually get the product out of the basin. And then to this well specifically, there were no operational challenges specific to this well that we encountered.
And I guess if I could say, no pipe got stuck when you were drilling this well. Is that what you mean by that?
That's correct. We were able to drill this to the intended TD and also complete all of the wellbore that we intended to.
Okay, perfect. One final question, Mr. Wall. Based on your expertise and experience in bringing wells online in the Uinta Basin, has a 300% risk compensation award fair, reasonable, and justified in this instance based on the drilling risks assumed?
Yes.
Okay. With that, I have no further questions for Mr. Wall. I'm done with my case in chief. Turn the time over to the division.
Division, please.
Thank you. We have no questions for Mr. Wall either. But with that said, the division has reviewed this request for agency action, and we reviewed the exhibits, and based on the testimony given today, the division is in support of this request for agency action by Ovintiv.
Board, do you have any questions for this witness?
Yeah. Yeah, can we go back to Exhibit K, I believe it was? Yeah, just out of curiosity, on the two wells that were drilled from that pad, the one to the west, which one was drilled first, the one to the west or the well we're talking about now?
Good question. I don't have that answer for you. Typically in this particular, when we drill multiple wells, one well may actually be spud technically before the other. But technically what we do is we'll drill a certain section of the hole and then we'll move over, drill the next well, that section, and then into the lateral, and then go back to the first well that was spud. So sorry, in this case, I don't know which well we technically spud.
I'd like to just note, technical spud, the spudding I understand happens fairly quickly, could be, within a day or two, but it looks like the production information, the date of first production is on there, and it looks like the western well came online 2 days before the Bar F well we're talking about today.
Okay. Do you remember any operational problems with the western well?
I don't. I think both of these wells drilled and completed pretty well.
Okay. All right. No, I have no further questions.
Thank you. Do we have any other board questions? Back to you, Mr. Mayo.
Thank you, Madam Chair. I this time it'd probably be appropriate to move for admission of our exhibits A through N. No, A through M. I apologize, typo. Exhibits A through M on file in this cause.
And exhibits N, O, and P will not be submitted.
And Exhibit N. It's not part of my presentation, but it is the publication. Yes, O and P were not submitted. Those
Okay.
were anticipated for the hearing examiner hearing.
Okay,
So,
thank you.
Exhibits A through N, please be admitted.
All right, so admitted. Board, would we like to deliberate, or are we ready to make a motion? Do I have a motion?
I move for the approval of the request for agency action.
I'll second.
All those in favor?
Aye.
That was unanimous. Please note, Gordon Moon, Steve Church, and Richard Borden are not present. Thank you. Mr. Mayo,
I'd be happy to, Madam Chair.
thank you. We'll wait to hear that, or to see that.
Okay.
All right, I think that concludes this issue.
Thank you.
Thank you, guys.
Thanks. We are now moving on to item number 4 on the docket. Docket number 2024-025, cause number UIC 626, in the matter of the application of Wesco Operating, Inc. for administrative approval of a major permit modification to the Cane Creek Unit 7-1 well, API 43019-50010, in Section 7, 26 South, 20 East, Grant County, Utah, as a Class 2 injection well. Please note that based on recent filings, there appears no longer to be a case or controversy before the board, and as such, this matter has been withdrawn, and the board will not address the matter today. Thank you. Moving on to the final docket item. Docket number 2024-019, cause number RMNRL 2024-01, in the matter of formal rulemaking to amend the large mining operation rules pertaining to weather changes to a large mine notice of intention to constitute revisions or amendments. Please note that this matter has been continued to the June 2024 board hearing. And I believe that concludes all the items on our agenda today. Very concise meeting today. Breakfast meeting. Do I hear a motion to adjourn?
I move that we adjourn.
So adjourned. Thank you.